Good afternoon. Welcome to Vertex Technopreneur Webinar Series, session number 3. Last week, my colleagues James and two very distinguished entrepreneurs and founder and CEO of their respective startups share with you many of the 5 points for fundraising and what the things to look out for when you're raising your round. This week, session number 3 will be focusing on the legal terms and agreements as a founder that you should be familiar with when you raise your financing. Today, we have two very good speakers with experience as lawyers and other graduating from a law school. And today, they are both our investment directors at the two different firms focusing on investing globally. The first speaker, Mr. Chan Hyok Choi, he's an investment director at Vertex Growth Fund. Hyok graduated from National University of Singapore with a law degree, and thereafter he worked for Allen & Gladhill as a lawyer before joining Vertex Growth Fund last year as an investment director at the Growth Fund. Hyok today focuses on investing in technology sector globally in the growth stage opportunity. Second speaker is Kevin Chua. He's a managing director of investment at Research Partners. Like Hyok, Kevin graduated from National University of Singapore with a law degree, and thereafter joined Allen & Gladhill as a partner, as a lawyer. Kevin thereafter joined Vertex Growth Fund as an investment director before moving on to join Visa as a managing director of investments. Visa Partners is part of NEC Corporations of Japan and focusing on private equity and mezzanine financing in the region. The next slide, please. We will be focusing on today the first 3 topics of the agenda, and there's 3 other topics which we will cover in session number 6, which will be in a couple of weeks from now. Before I hand over the presentation to Hyok and Kevin, I would like to highlight to everybody there's a button at the bottom of the screen called Q&A, allow you to submit questions to the presenters. And I'll be monitoring the Q&A and posting some of these questions to the presenter, during the process. Without further ado, let me hand over the presentation to Hyok.
Thanks, Kilok, for the kind introduction. To start off, as a founder, there are many different funding options you might undertake when doing fundraising. Broadly, we can split this into 2 categories, equity and debt. So equity refers to fundraising via an issuance of shares for a sum of money from an investor. And debt, on the other hand, refers to fundraising via a loan. But this is in VC, we don't see it as a typical type of bank loan that we know of, but there's an equity component in these instruments. So one fundamental question entrepreneurs might ask is, should a company fundraise via debt or equity? The short answer is that actually there's no better option and really depends on what you wish to prioritize. And the longer answer is to actually look at this question from 3 perspectives. The first would be transaction cost, second, control, and third, valuation. From a transaction cost perspective, debt instruments actually has a lighter touch compared to equity. The process would usually be shorter and legal costs tend to be lower, as there are lesser terms and lesser complex terms for both founders and investors to negotiate on. For control, that actually allows founders to retain more control because as note holders, you don't have voting rights or information rights or typical shareholder rights. But at this juncture, it's worth highlighting a potential trade-off for control, which is the strategic value that investors can bring to the table. Because investors in equity fundraising, if you look at it, will be shareholders of your company. So they would have information rights and voting rights. And these investors would typically also be more involved in a company, and they will be able to provide advice, business opportunities, or even expertise. So in fundraising, we will advise founders to not just consider the funds that an investor can give you, but also consider the strategic value that an investor can bring to your company as a shareholder. From a valuation perspective, that actually allows founders to postpone the valuation of the company. And what this means is that if you as a founder think that your company would be worth much more in the next equity fundraising round, compared to a valuation at the present moment, then issuing convertible note right now might make more sense because the dilutive effect will be lesser when the note converts at a much higher valuation at the next round. as compared to if you issue equity at a much lower valuation now. But at this juncture, there are two points of caution that we would like to highlight. The first is that for convertible notes, it is very likely that investors will ask for a valuation cap. And with a valuation cap, the founder could actually end up giving up much more equity in the future fundraising rounds. So for example, if you have a valuation cap of 100 million, and the subsequent round down the road was actually priced at 200 million, the convertible note will actually convert at a cap amount of 100 million and not 200 million. And in so doing, actually, you as a founder might actually be diluted at a much larger stake than expected. Second, if you look at convertible notes, it also has interest payments and potentially principal repayment. So founders, you have to consider the cash flow implications on your business based on these instruments. Another equity fundraising feature is actually warrants. What a warrant does is to give an investor a right to purchase an additional amount of shares within a future time frame on top of the investor's investment amount. So the investor will actually pay for these additional shares when they decide to exercise this right. The rationale is really to act as a kicker or a sweetener to the investor. And there are a couple of things we wish to highlight from a founder's perspective. The first is, given that warrant shares are actually an issuance of, it's a right to issue shares, you have to also seek the shareholders' approval. So you cannot give up warrants without the other shareholders knowing. The second is that it is useful as a make-weight if the investor wants to have a lower valuation. So instead of agreeing to a lower valuation, you could also offer to the investor as a sweetener these warrant shares. So essentially, the investor can then wait and see. And if the company continues to track and do well, then the investor can actually subscribe for more shares at the last fundraising price. The next is that the warrant shares usually have liquidation preference. They do not usually have liquidation preference, redemption rights, or dividend rights because these shares are not yet issued. And the last thing is that for warrant shares, there are a couple of features that founders should also be aware of. The first is the exercise price. When we look at the exercise price of warrants, it's usually the price at which the investor can purchase the warrant shares. And this is usually pegged to the last round fundraising price. Second would be warrant coverage percentage. And this is the number of warrant shares that the investor can exercise the option to purchase. So for example, if we say that there's a 10% warrant coverage percentage, this means that if the investor had invested 10 million, there's an additional 1 million worth of shares for the investor to exercise his right and to purchase this 1 million worth of shares after the 10 million investment. For partial or full exercise, if we go along the same example, if it's partial exercise, it means that the 1 million worth of shares can be exercised in different tranches across the term of the warrant. But if it's full exercise, it means that the investor must exercise the 1 million at one go. For term, it's usually 1 to 2 years, but take note that there's also an automatic expiration of the warrant at the next fundraising or if any exit happens earlier than the end of the term. There will be typical transfer restrictions, and founders should also take note when you send over or send across the capitalization table, you should also include the warrants because it would affect the investor's dilution of his stake.
Now I'll move on to talk about the debt fundraising options. Very broadly, we have three different kinds of instruments: SAFE, venture debt, and convertible loan. Although I'll mention at the outset, SAFE is strictly not actually debt, but rather it's a convertible security, but it's similar to the other forms of debt, and hence we decided to discuss this together as comparison. So SAFE is basically a simple alternative because it has minimal terms and it's quicker to execute. It gives the investor the right to subscribe for future equity, which is very much similar to a warrant. The main difference between a SAFE and a warrant is that the SAFE, the investor provides the money upfront. However, they only get the shares at the later equity round. But for the warrant, the investor gets both the shares and pay the investment amount when they exercise the warrant. Hence, the implication for a SAFE is that if the company fails to raise a future equity round, the investor who has a SAFE would have effectively lost money as well as not gotten any shares. Moving on to talk about venture debt, it's typically a senior secured debt instrument. and it will come with warrants exercisable at the previous round's price. One thing to distinguish between venture debt and convertible loan is that venture debt, the principal is usually repaid in cash, and sometimes the lenders may require the company to pay down the principal amount periodically. For convertible loan, it can be either secured or unsecured, but typically we see that it's usually unsecured debt instruments, and this is usually raised for the purpose of a bridging round, and the conversion price will be at a pre-agreed discount to the next round's price. We usually see between 10 to 20% discount. And as mentioned, the difference is that the principal and interest is repaid in kind, not in cash, meaning the outstanding amount will be converted into shares and issued to the lender. Hence, the cash flow implication for the company is less. So from the founder's perspective, what are things to take into account for these three instruments? So the SAFE instrument is most commonly used in the seed stage companies. However, more recently, we have found that in crises, companies will also tend to raise SAFE note as they want to defer the discussion of valuation, especially for mature companies, to a later stage. So a couple of advantages of a SAFE note. First, the startup is able to receive the money quickly, and there's no need to agree on the company's valuation at this point in time. Another key benefit is that there's less bureaucracy at the early stages of the company, especially when the startup needs to make decisions and move very quickly. Because the SAFE investors are technically not equity shareholders, and hence they do not have voting rights or the right to participate in the management of the company. However, founders should be careful of not raising too much SAFE and be careful of its potential dilutive effect, because it's only felt at a later stage when equity is raised. For venture debt, it's generally more suitable for companies at their later stages of growth or at their growth inflection point. Founders should consider the cash flow implications from the interest and principal amount periodic repayment. However, venture debt is generally less dilutive compared to the convertible loans, and venture debt would generally come with higher interest rate comfort. For convertible loans, these are more often used as sort of a bridging round between equity rounds to give the company more cash and more time to grow the company to a larger scale. Typically, convertible loans, as mentioned, are repaid in kind, and this hence minimizes the ownership dilution. And however, founders should take note that if an equity round is not raised before the note maturity, they will have to ensure that they have enough cash on their balance sheet in order to repay this convertible loan as well. Some general considerations, I want to go through all of them. However, I'll highlight a few key points. For SAFE, you want to take note whether to provide for a pre-money valuation cap, and as Help has explained earlier on the implications of having this. And then you also want to negotiate for the discount, and as well as what's the time limit and whether it's sufficient enough for you to raise equity in order for the investor to convert the note. One other concept for SAFE is the qualifying raise. What this means is whether there should be a minimum amount that the founder raises in the next equity round in order for the SAFE to be triggered. For venture debt, just pay attention to the interest rate, which we generally see in the range of between 9 to 15%, and also consider if it's secure, what should the security coverage percentage be. And the loan tenure is, as mentioned, longer, and usually between 2 to 3 years. And lastly, for convertible note, the interest is usually accrued on the outstanding amount until it's converted. Also consider here the issue of a pre-money valuation cap. It usually comes with a shorter tenure of between 12 to 18 months, given its bridging nature. And it also comes with a lower interest rate than venture debt, usually between 4 to 8%.
So in this section, we will go through the expectations for the due process and more practical considerations when dealing with lawyers and legal documentation in this process. When we look at the entire due process, we can split it into 3 stages. The first is the term sheet stage. The second would be due diligence, and the third would be documentation. At the term sheet stage, the terms in any term sheet is non-exhaustive and non-binding. That means that none of the founders or investors can actually enforce it on it, even though both parties have signed on this term sheet. However, we wish to highlight to founders that they should still treat it seriously, and this is the stage where it's best to include your must-haves or negotiate the cannot-have terms, because this will then make your negotiation in the later stages smoother, since parties typically will not stray away from the term sheet unless there's very good reason to do so. It's also good at this stage to find out your investors' own internal approval process to get a sense of the timeline they work on. This will be especially important if your company needs money urgently. At the second stage, the due diligence stage, we advise companies to be as truthful as possible, because they should try to avoid the post-investment situation of investors actually uncovering material facts that was not disclosed previously. This would severely impact the trust between founders and the company, founders and investors, and could potentially open the founders to legal liability. And the last would be the documentation stage. This is where the lawyers come in to do the drafting and the negotiation for the main documents, such as the shareholders agreement and the subscription agreement. Either the company's lawyers or the investors' lawyers will be the ones producing the draft of the agreements, or amend the previous fundraising documents to incorporate the term sheet that was previously agreed between company and the investors. So at this juncture, we also encourage founders to have their lawyers to hold the pen for the first round, so you can control the terms that would go into the agreement. In the documentation stage, there are two key things we wish to highlight. The first is, after the first draft of agreements that incorporates the term sheet sent across to the investor lawyers or recipient lawyers, if it's your lawyers, we would recommend that you ask for either your lawyers or the investor lawyers to produce an issues list before the recipient lawyers amend the next agreement. So this issues list is basically a laundry list of positions in the agreement which the investor does not agree with the company and would like to propose certain changes to the agreement. The purpose is really just to scope out all the material issues for discussion before the lawyers actually amend the agreements. So at this stage where the parties should then negotiate heavily on the issues list and then come to commercially agreed positions before the lawyers start drafting. If you follow this process, there should usually not be more than 2 to 3 turns of documents between both sides. And overall, the key benefit really is to save time, legal costs, and to ensure that the negotiations are smoother and focused, and parties will not miss anything, will not be to avoid any surprises. So while we see that good law firms usually follow this arrangement, we have also seen that it is very common for many law firms to not follow this practice. Therefore, we highly recommend that you check in with your lawyers to ensure that this process is undertaken.
Now I'll cover some practical tips and general considerations when it comes to the deal process and legal documentation. So first, on legal documentation, we generally advise founders not to include terms in the legal documents just for the sake of having them there. You should consider that even if these terms are in the documents, in the worst case scenario, what do they protect and are they sufficient? And also think about if there are any disputes, will you be able to, or are you going to plan to enforce these terms against your investors to enforce them? If practically the answer is no, then maybe you should consider letting this point go, especially if the other party feels very strongly against it. Secondly, when it comes to negotiations, you should put yourself in the counterparty's shoes and consider if whatever you're asking him, if you were him, would it be acceptable or reasonable to you? Also, think about and anticipate what the investors' counter arguments might be, and before entering a negotiation with them, prepare some counter arguments as rebuttal. Also, refrain from introducing non-market standard terms or bring up demands that are not crucial or necessary and subsequently negotiating these points away. This can be very time-consuming and can be distracting in the process. For some new founders or first-time founders, if you are unsure about the market standard terms, you may refer to the Singapore VC Association's model agreements for reference. The link is provided on the slide there. They provide various model standard agreements ranging from NDAs to term sheets as well as shareholder agreements. Next, for legal documents, you should think about enforcing the terms in the long term and bear in mind the implication of agreeing to certain terms at this juncture and what it could mean for the future. Because if you were to allow certain investors to get special terms now, it may be onerous as you raise more rounds and bring on more investors because they could ask for the same terms or perhaps even more onerous. This could affect things like exit, control, operational flexibility. And lastly, we also want to mention that generally as a rule of thumb, when it comes to legal drafting, try to be as specific as possible for terms that are against you in order to limit your liability, and the opposite for terms that are in your favor. As a practical tip, we also recommend not using lawyers as a postman or messenger. To minimize legal costs and time, we suggest that you go straight to the investors to discuss the key commercial issues and instruct lawyers to amend the documents when these key issues have been agreed upon. CFIUS. CFIUS stands for Committee on Foreign Investment in the US. And this committee basically regulates investments in US businesses that could have the potential national security concerns in the US. It was amended recently in 2019 to become broader and stricter. And to be honest, most people and lawyers are still quite unclear how to interpret its scope and breadth. But generally, if you think your business has a nexus to US, you probably have large, substantial operations, revenue, or maybe even develop some R&D or IP in the US. So if so, you may wish to seek legal advice on whether the CFIUS regulations apply. The implication that if these regulations apply is that you would have to file a declaration with the regulator and seek their approval before you are able to close your transaction. This could have time implications in delaying you from closing a deal. Also, the penalties for not doing so is that the regulator would be able to retrospectively unwind your transaction and impose a penalty on the investors as well as the company. So we recommend always, if you are unsure, to seek a legal opinion on whether these regulations will apply. Last point I would like to talk about is NDAs. We understand that most companies would wish for potential investors to sign NDAs to protect their intellectual property or their business idea. However, in practice, we often advise founders that many investors are not willing to sign an NDA at the outset unless they have a serious interest to invest in the company. 3 points that we would advise founders as well is that prominent VCs often treasure their reputation and they are unwilling to risk it by sharing confidential information with third parties. Second, as a startup is quickly growing and developing, often the information may become outdated or public information in a few months anyway. And lastly, if there's still concern, we suggest that founders should talk to the VCs upfront and ask if they have any similar portfolio companies or if they are concurrently looking at companies in a similar space to decide how much that your proprietary information you're willing to share with them during that meeting. We think that NDAs are perhaps more justifiable at later stages when the company has more proprietary technology and IP, and which may compromise the company's leader position if they are leaked.
So before you move on, Hyuk and Kevin, there are quite a number of questions. So I was looking through it. Those that are questions that are clearer, more relevant, I will probably pose it to you now before we move on to the next section. One of the questions is from one of the participants. Is asked when we use lawyer to draft a term sheet, but VC usually have their standard term sheet, and what does the startup and the VC usually settle on? And what if multiple VC and different term sheet? How do we come to terms with so many different versions? So I think this is one of the questions. Either one of you can touch on that topics.
Maybe I'll go first. I mean, yes, we've also seen many varying forms of term sheets over our times when we deal with different VCs, investors, and startups. I think a good way is to smoothen out the process, especially for the more reputable and larger VCs you're dealing with, is to go with their base. If you were to go with their base, and then you can use the VIMA model agreements as a reference point to see whether these are market standard terms. And if they deviate quite substantially, you may wish to mark those terms up. Or if they are not even in a model agreement, you may wish to take a closer look to consider whether these are acceptable to you or whether you should remove it. But maybe when the company is at a later stage of your growth, and then you're talking to multiple investors when raising a round, maybe it may make more sense to send the investors your standard term sheet and tell them that this is the standard that you have shown to all the potential investors, and to expedite the process, request that they use the standard that you have given them.
Okay, you said another questions, I guess somebody asked about, maybe I combine a few of them together, is about law firm. I guess we all talks about getting better law firm, bigger law firm, but all bigger law firm and better law firm is generally more expensive. And how do you handle this? I guess maybe Hyuk can explain this.
Yeah, sure. So yeah, it is true that if you use a larger law firm, it would generally be more expensive. And because price in some sense is there's correlation with the firm and the partner's experience and also the branding. But one thing to note is that the lawyers themselves see the work with clients as building a long-term relationship. So law firms, just like VC, they want to be associated with success stories. If you are able to actually get the right referrals, get them to see the value of what you're trying to create, certain firms will try to do what's necessary to work with your startup. And having said that, sometimes it's also not just about the firm. You have to also look at, maybe it could be the partner or the associate that's involved. So it will be good to actually find out what the deals they had done previously, and perhaps actually have a conversation with the lawyers, with the startups that these lawyers had worked with previously, to understand if they actually have done a good job. But ultimately, I think the bottom line is we highly recommend that you hire a lawyer experienced in VC at the start of your fundraising, because the subsequent fundraising rounds will be based on the initial documents drafted by your first lawyer. So if the initial documents are actually not drafted well or negotiated well, it will be very difficult to change the terms in subsequent fundraising rounds, unless your company has done exceptionally well. And the other thing is that you might unnecessarily incur additional legal fees if you have to engage a new lawyer to clean up the documents in subsequent fundraising rounds that was drafted poorly by the previous lawyer.
I guess the many question, maybe last question is about cost, I guess. What will be a typical transaction cost for typical cost or legal cost for each transaction? Hyuk, maybe you can answer that.
Yeah, sure. For VC legal deals, it really depends on the complexity of the deal and the number of investors. So the higher the complexity, so for example, equity fundraising would surely have higher legal fees compared to issuing convertible note. Or if the deal has a very different bespoke terms that will be very complex, then it will be more complex and higher fees. The other thing is whether it depends on the number of investors that are involved, because the lawyers will then require more coordination. So for early stage, we will usually see around 10 to 30K per USD, 10 to 30K per transaction. And for later stage rounds, after the angel rounds, we typically see like it's 30 to 100K USD. But you should also be mindful, founders should also be mindful that the investors will also ask you to pay for their legal fees too. And a couple of things to note is, the first is that it should, as far as possible, be limited to the lead investor legal fees. That's one. And the other thing that you should always note is, you should always cap the legal fees for both the VC and your own lawyers. This fee cap should be reflected in the term sheet and also reflected in the fee quote that you have with the lawyers at any stage, at any point.
I would jump in here to mention that the amount of fees you agree to cover the investor, you should also bear in mind that this should cover legal due diligence costs, legal drafting costs, and also financial due diligence costs. So you need to make sure that the amount you agree with the investor is more than what the lawyer has quoted you, so that you can cover for the financial due diligence as well.
Good. Thank you very much. Maybe we can continue on, because there's a lot of questions coming in. Maybe some of them we cannot answer this time. Okay, please continue with Hyuk and Kevin.
Yeah. So in this section, we will actually look at the terms affecting the division of economic benefits for both the investors and founders. And in this case, the most crucial term to watch out for is the liquidation preference. This is the mechanism which determines the order of payout and how much the payout would be when there's a liquidation event. And in any liquidation event, the investor has two options. So either he can choose to exercise his liquidation preference, or he can choose not to exercise and convert his shares to ordinary shares. So this liquidation preference is important because it is the investor's right to actually get his or her money back before the ordinary shareholders, which includes the founders and the employees. And it also serves as downside protection for the investors when the company exits at a value lower than expected. Conversely, this clause is very important to founders because the drafting would actually determine how much returns will be left on the table for the founders and employees after giving to investors. So before we go to the features of the liquidation preference, we know that this right only arises when there's a liquidation event. And the liquidation event must always cover four scenarios. The first is winding up. Second would be acquisitions or takeovers. The third would be trade sale, and fourth, share sale. Just a minor distinction between trade sale and share sale is that trade sale is selling the assets. Share sale is selling the shares of the company, which would then include the assets as well. So essentially, trade sale is a subset of share sale. For the other thing to note is that for sometimes investors might ask for substantial disposals to be included as a liquidation event. This is when if the subsidiaries, there's actually many operating subsidiaries which are independently operating of each other, or if it's very late stage where the exits could be piecemeal rather than through the holding company. This is when substantial disposals would be considered a liquidation event. The other point would be, the other important concept to take note is that IPO, while it's considered an exit event, is not considered a liquidation event. This is because at IPO, all shares will automatically be triggered to convert to ordinary shares. So there's no liquidation preference involved in such a case. To understand what are the key features of liquidation preference, founders should take note of these few features. The first is the seniority, whether it's senior or pari passu. So when we mentioned that it's senior liquidation preference, it means that within the different liquidation preference stack, the more senior liquidation preference gets the money first, then followed by the junior liquidation preference. So Series A gets money first, followed by Series B. If it's pari passu, it means that there's no difference. Series A and Series B will get the money at the same time. Of course, the importance is that if there's not enough money on the table, then Series A would get less money if there's seniority involved. The second would be the preference multiple. So this is the part which determines the amount the investor can receive before the ordinary shareholders start receiving any proceeds. So if it's 1x investment amount, it means that the liquidation preference is, if the investor invested 5 million, he has to get back 5 million as a liquidation preference. If it's 2x, then it's 10 million. So of course, needless to say, the higher multiple would be more pro-investor and the lower multiple is pro-founder. The third would be the participating right. So when we mention that there's a participating right, that means that the investor not just has the liquidation preference, he can then also participate in the remaining proceeds that's left on the table. So in this case, if the investor has taken the liquidation preference of 5 million, and whatever there's left of the remaining proceeds, the investor can also share the remaining proceeds based on the shareholding he has. So of course, this is pro-investor compared to a non-participating right, which is more pro-founder. Regarding the cap is more pro-founder compared to an uncapped, which is more pro-investor. So when we say there's a cap, it means that there's a numerical limit on the investor returns from the liquidation preference and participation right. And the last will be interest rate. So the interest rate is rarely seen in the Southeast Asian context, but if there is an interest, it means that there's an interest to be paid to the investors that will be accumulated every year until that will be payable until at the liquidation event. So typically the interest rate we see will be around 8%. So to give an illustration of the liquidation preference, assuming we have a company which is raising 5 million from one Series A investor at a pre-money of 5 million. So this gives them a post-money of 10 million, and therefore the investor has a 50% shareholding. We then assume there's a one-time participating liquidation preference with 3x cap. So the returns available to actually the Series A investors and the ordinary shareholders will differ based on the different points of exit valuation. So the green is the investor's return and the blue is the ordinary shareholder's return. So if you look at the left, assuming the company does not do so well, there's a liquidation event for 5 million. So in this case, since the Series A investor has 1 times liquidation preference, the Series A investor will get everything and the ordinary shareholders get nothing. But at any point above 5 million, the ordinary shareholders will get some proceeds. But if you recall, there's a participating liquidation preference. So with the participating right, the investor would actually double dip in the proceeds and would actually share in the remaining proceeds. So if you look at the 15 million mark, once the Series A shareholder takes his liquidation preference of 5 million, he will still continue to participate in the remaining 10 million. And that will only leave 5 million for the investors, for the ordinary shareholders. If you recall, there's actually also a 3x cap. So how this functions is that with a 3x cap, the investor can only receive 3 times of 5 million, so 15 million when you calculate the liquidation preference and participation right. So if you look at the portion of the graph which platoons at 15 million, the investor is unable to get any more between the 25 to 30 million mark. And if he wants to get any more, he has to actually exercise the other option of converting all his shares to ordinary shares. So that's when, if you look at the 30 million mark, the investor would actually be better off converting everything to ordinary shares, because by having a 50% share is actually more than his cap participation.
Okay, now I'll be talking about redemption rights. Redemption rights are typically is the right to require the company to pay cash to buy back the investor shares, and there are 2 types: mandatory or voluntary. Voluntary redemption rights means that the investors as a class can, within a specific period, vote by majority to require the company to buy out their entire series of shares. And for mandatory, by its definition, it's the company is required to buy the investors out by the end of the specified period, and the investors do not need to vote in favor of it or not. It happens automatically. So while we will mention that redemption rights are mainly to help investors protect their downside, and as well as to provide them with a form of exit at the end of the specified period. However, in practice, we have rarely seen this right being exercised by the investors. And a couple of points that to consider from a founder's perspective. First is what should the trigger event for this right of redemption and vote be by? And also consider whether the redemption period. So this is a key point, because typically subsequent rounds will peg to the same redemption period as the Series A terms. So hence, founders should consider at the Series A round, when they agree to the redemption period, is there sufficient time for building the company and for them to exit the company, or whether this period should be extended. Third, as mentioned, optional or mandatory or both. And fourth, the redemption price. Typically, what we have seen is that it's computed based on the higher of issue price with interest accrued, or the fair market value as determined by a third-party valuer. Moving on to talk about exit, I'll touch on this very briefly for today, because we'll cover this in the exit terms in more detail in session 6. But very generally, founders should consider the exit terms for IPO or trade sale to see if it may result in a premature exit of the company, or allow investors to force the founders to sell before the company has achieved a satisfactory size and valuation. So from the founder's perspective, a few key points to consider: the time period, approval thresholds, and whether to have conditions such as a minimum valuation for exit. Typically, we see the minimum valuations being set at the later stages of the company. However, minimum exit valuation is a double-edged sword. On one hand, it can prevent an exit, hence the company, assuming the company has not been able to achieve the valuation, then all investors, all parties are unable to exit. But on the other hand, it can also protect founders by preventing the investors from requesting or forcing a premature exit. So these above 3 points, the same conditions could be requested for or made more onerous in the future fundraising rounds. So for example, it could also have implications on the future fundraising rounds. For example, if a valuation to revenue growth multiple was set at this current round, and then it was not achieved at the next round, this could give a bargaining chip to the existing investors or the new incoming investors to request for a lower valuation. And lastly, to talk about alternative exit clause, this basically allows all parties to vote in favor of appointing a third-party advisor to seek relevant exit opportunities. And the above 3 points discussed on valuation, term, etc. Would apply for this as well. And we'll say that the alternative exit clause is recommended to be included because if all else fails, all other alternative exit fails, at least this would allow everyone to seek an alternative to exit. Moving on to talk about employee stock option. There are 2 different kinds: pre-money increase and post-money increase. As the name suggests, one is before closing and the other is after closing. The post-closing ESOP increase is more founder-friendly because everyone is diluted, including the new investors. However, pre-closing increase would only benefit the investor because the founders and other existing shareholders will be diluted. Typically, investors want to minimize the risk of future dilution by making the ESOP pool as large as possible now, rather than incrementally increasing it in the future, because there will be uncertainty as to how much the current existing investors will be diluted later on. But founders should consider if the unallocated option pool is large enough for the current management as well as for future key management hires. On dividends, likewise, there's also two types, cumulative and non-cumulative. The difference is that for cumulative dividends, they will continuously continue to accrue even if the company does not declare a dividend. And this will be paid out at the end when during the exit or as and when the company declares a dividend. This basically provides the shareholders with a guarantee on the minimum return and also take note that the dividends would usually be paid on preferred shareholders first. Non-cumulative are more founder-friendly and is more common in most transactions we've seen. So basically what it means is that the dividends will only accrue if the company declares a dividend for the year. So there will be no dividends in arrear appearing on your balance sheet. The typical dividend rate is around 8%. And I will also point out that under Singapore law, if the company is not profit-making, it is unable to declare any dividends because dividends can only be shared if the company is profitable. Anti-dilution provisions are a key concern for any investor. These provisions protect an investor from being diluted in the future, especially during a down round financing, by adjusting the share conversion price and the amount of shares the investor is entitled to during conversion. From the founder's perspective, Full Ratchet is the least founder-friendly, and I will elaborate more later. And also, it provides the least incentive to the existing shareholders to participate in the new round because they'll basically be entitled to the same amount of shares on an as converted basis, even if they were not to invest in the new round. This also could affect the new investors' willingness to invest more money into the company because the company will have more shares due to the adjustment on an as converted basis. At this point, I also want to point out, please take note that the conversion, this mechanism adjustment does not mean that the company will be issuing more preference shares to the existing investors now, but instead allows the existing shareholders to convert subsequently and get more ordinary shares. This chart here shows you the three different methods of calculating the anti-dilution. With the broad-based weighted average being the most founder-friendly and most common, Full Ratchet is the least founder-friendly and least common. The difference between these three methods is the calculation of how the prior shares, the number of prior shares is calculated, or whether to disregard it entirely. Between the broad and narrow-based approach, broad takes into account all outstanding securities, meaning options, ordinary shares, preference shares. However, narrow only takes into account the preferred shares. Hence, the conversion price is adjusted vis-a-vis the preferred shares only, and this will be more dilutive to founders. For Full Ratchet, it disregards the total number of outstanding shares of the company, and hence it basically just reduces the previous issue price to the same new share price. This is just a quick illustration. I won't go through it in detail, but this illustration shows you the extent as to the difference in dilution between each of the mechanism because of the adjustment to the conversion price. Next, preemption rights. This is also another key term that is of importance to the investors. So basically, when the company proposes to issue new shares in a new fundraising round, the company must first offer a portion of the new shares to the existing investors to allow them to maintain their shareholding percentage in the company. They will have the existing investors will have the right to take up the shares proportionate to its shareholding allocation in the new round. I also mentioned preemption rights very generally from a legal point of view also refers to preemption rights over transfer of shares, such as right of first refusal or right of first offer, which we'll cover in session 6. But in VC transactions, most commonly it refers to preemption rights over share issuances. So if the existing shareholders were to reject the right to take up the existing shares, depending on how the clause is worded, either the company will have to offer it to the other existing shareholders who have taken up the right, or they would have to offer it directly to the new investor. From the founder's perspective, this right is generally offered to all shareholders in earlier rounds, but subsequently it will be trimmed down only to the major investors, so that you don't have to offer all shareholders, including those very minority shareholders, more shares, and this may create more dilution for the founders. Also, it's uncommon to give a super pro rata right, meaning the right for the existing investor to subscribe for more shares than is necessary to maintain their pro rata shareholding percentage. And we recommend not giving a super pro rata right because this may scare off future investors or provide too small round allocation for the new investor if the existing investors were to take up too much new shares.
Before we continue, I think there's also quite a lot of questions. So I will pick a couple of questions, and some of them we may not be able to address it today. We'll attempt to answer them in session 6, perhaps before we present the session 6. So maybe perhaps the first question is for Hyok. One of the questions is that in terms of liquidation preference, is it a good idea to provide 2x or more in liquidation preference?
I think when we look at liquidation preference, one key principle that founders should remember, and this was actually mentioned by Kevin earlier as well, is that whatever you provide for this round, you have to apply in future rounds. So if today you are giving 2x, all future rounds you'll be giving 2x. And having said that, most transactions, what we see is 1 times liquidation preference. But there are times where we see 2 times or more liquidation preference, is when investors either consider the valuation to be excessive, and then they want the liquidation preference to compensate for any downside risk. And we have also seen 2x or more liquidation preference when the company is of course having more difficulties getting support from its existing investors. But at least in terms of participating right, still, even if you give the 2x for the participating right, you should know that it's still relatively common for VC firms to have participating right as well, unlike in the US. So this is more common in Southeast Asia, but this is still subject to negotiation, of course.
I guess I think one more question before we move on. I guess this is relating to ESOP. I suppose it's for Kevin. What is the typical vesting period for ESOP, and how do you determine the exercise price for ESOP?
Okay, on vesting period, we typically see about 3 to 5 years, most commonly. And on the discount, usually in the early stages of the company, where you issue ESOP to the early employees of the company, usually the discount is much more substantial, maybe even up to 80%. But then as the company continues to grow and develop and more ESOP is being allocated and issued, then we tend to see a smaller discount, maybe 10 to 20%. And also founders should bear in mind that at later stages of the company, you have to start thinking about your exit and your IPO. And when if you were to go IPO in US, the SEC would actually look at your historical ESOP issuances to make sure that you did not issue so-called cheap shares to your employees by giving them a huge discount. This could potentially affect your P&L.
All right. Maybe there's a lot of questions we may not be able to address in today's session. What we do to attempt to answer them in maybe session 6 before we presented session 6 a couple of weeks from now. So maybe Hyok, and Kevin, please continue.
Yeah, so in this section, we will discuss the terms that impact control over decision making. One of such terms would be the reserve matters, and there are 2 types. So the first type is the shareholder or lead investor reserve matters. This is a list of matters which the companies must seek the shareholders or lead investors' approval before going ahead. And the rationale is really for investor protection by giving them a veto right over certain matters. However, what we see is that while investor protection will be important for investors, founders must also realize that they need to exercise caution in balancing the administrative burden that these matters can give to the company. So if the approval threshold is too high, it can be quite administratively burdensome on the company. And what we suggest, we have a couple of suggested approaches to take. So the first is to actually lower the approval threshold. So for example, for later stage companies especially, it's best to limit to just a few lead investors to seek approval from rather than all lead investors. Or it is also possible to lower the approval threshold from 75% to 51%. The second thing that you could adopt is to actually separate the reserve matters into different approval thresholds. So for more important matters, you would say it's 75%, but for the less important ones, then maybe 51%. And the last is to actually, the founders should, as far as possible, try to ensure that for any shareholders' reserve matters, the shareholders do not vote in separate classes. Voting in separate classes means you have to seek Series A, Series B, Series C investor approval separately. And if one class does not agree, then the matter cannot pass through. So as far as possible, at least in the earlier stages, it's best not to have too many different classes that are voting separately. To give a flavor of what type of matters there are, so we can actually classify into 3 broad types of matters. The first is the matters affecting shares. Second would be matters affecting exit. These 2 are especially important to the investors, and it will be very hard to bargain away. So, and it's usually a standard list of matters. The last one, operational matters. This is something that there could be some negotiation over, especially these type of matters. And one suggested approach we recommend founders is that you could actually set a minimum threshold to ensure that you don't have to seek approval for every little small matter. So for example, if you look at number 4, it's acquisition above a certain monetary value. For board reserve matters, it's actually the same as investor or shareholders reserve matters. The only difference is that you need to seek the board for approval rather than the shareholders for approval. So there are 3 types of matters. The first is the founders or key employee matters. The second would be transactional matters. And the third would be operational matters. So likewise, you can also adopt the same principle by including minimum thresholds or ordinary course of business thresholds, so that you do not have to seek approval for small matters under the minimum threshold or seek approval for matters in the ordinary course of business. This is to allow, as what we mentioned earlier, to make it operationally more efficient for the company.
I would chime in just to add to Hyok's points is that the difference between whether it should be a board reserve matter or a shareholder reserve matter is generally board reserve matters pertain to the operations of the company, the day-to-day business transactions of the company, whereas for shareholder crucial rights like the voting rights regarding their shares, these are usually shareholder reserve matters. And this is because so that it's more efficient, you do not need to go all the way to the shareholders to get approval. The board can simply convene a meeting and pass the decision. Okay, now I'll move on to talk about board representation. So it's quite standard to provide major investors with a right to appoint a board representative, and they can be helpful in providing guidance and strategic advice to the company, given their experience. However, the founders should weigh this against the administrative burden of having too large a board size. So hence we recommend that if to manage a board size, founders should consider whether to include a minimum threshold in order for the investor to maintain a board seat. So moving on to talking about quorum. So there's this concept of quorum for both shareholder meetings and board meetings. So quorum, we recommend that the quorum list should only be kept to the key directors and shareholders that are actively participating in the company or the business and are also aligned in interests generally with the major investors and the founders. Many people may think that this ensures that all parties, all members will be called to the meeting. However, we advise parties, founders to consider this more of as a wartime right. For example, when the company is not doing well. Because quorum is what we have seen based on past transactions, that quorum is often used as a weapon to frustrate the company's operations and allow the investors to hold the company hostage, especially when the company is not performing or facing major issues. And hence, these directors or shareholders on the quorum list would intentionally choose not to attend the meeting because they just can't be bothered with the company anymore. Next, and lastly, talking about information rights, this is very standard to provide to the investors because this mainly allows investors to monitor the company and the progress. Key points for founders to consider is the time required to provide the information by. Is it feasible? Secondly, type of information that will be provided. And lastly, who should have the right to such information? And at later stages, you may wish to limit this to only major shareholders so that you can sort of reduce the administrative burden. So some common types of information that investors will ask for is financials, the annual budget, as well as the capitalization table. mainly to keep track of the issuance of ESOPs. And if founders are concerned about confidentiality, we will point out that most shareholders agreements, there will be a standard confidentiality clause therein. Alternatively, you would look at the term sheet example below. Perhaps founders can consider reserving a right to withhold certain information on the basis or on the grounds of it being trade secrets, etc. And this brings us to the end of our presentation for today. Please feel free to reach out to Hyok and I separately, offline. If you have any questions, you may find us on LinkedIn or email us. Yeah. And in the next session, maybe I'll hand over to Keelok.
Yeah, so before we go on the next session, talking about some other logistics, there one question actually from our audience talking about reason matter. That's mostly for Hyok. It talks about the list is usually very extensive and it could hinder the operation in the future. The question is it a good idea to agree to such a lease? That is a question from one of the participants here.
I think for the list, the reserve matters list, we have to look at the reserve matters list from a first principle point of view, because considering that the VC has actually paid a higher price by valuing the company more than what the founders have put in, they might want certain safeguards to ensure that the founders are actually applying the money to the business and sensibly. So while the list may be long, it's generally centered around matters to ensure that the business is managed well, or steps are taken to, or steps are not taken to hurt the business. So for example, you cannot divest key assets without their approval. But we can understand that there is some operational aspects for the company. So rather than just agreeing to the list, it is best to look at the list at every matter and to see if the company can actually fulfill this list. And the other way is also to set minimum thresholds to certain operational matters that if it's in the ordinary course of business or below a minimum sum, then there is no need to go to the shareholders or the board for approval.
Okay. Yeah, another way I think you can think about reserve matters is because it's fairly standard. Most transactions we have seen always have reserve matters. Another way is, as Hyok mentioned, is to do separate the list of matters. So for one particular set of matters, you can have a different approval threshold, maybe 75%, and maybe a separate list of approval matters, you can have a lower threshold of approval. Yeah.
All right, well, this is bringing us almost the end of this session. Thank you very much, Hyok and Kevin, for the presentation. As mentioned earlier, that there's a session 6 which talks more about other rights like IPO and other matters, which I think is important. I encourage you to sign up for it, which will be a couple of weeks from now. And some of the questions, sorry, we could not address it today. We will attempt to answer some of them before the session on the session 6. Perhaps Hyok can give me the next slide, please. So the next session will be session 4, which will be conducted about September 4. We'll be taking 1 week break next week, following by September 4th, talking about scaling up and cross-border expansion. This is a very interesting topic for many entrepreneurs to think about. We invited 2 very experienced entrepreneurs. First of all is Jeffrey, who is the founder and CEO of PetSnap. He's running truly a global company with 800 over employees globally. So he has many experience to share about scaling up and cross-border expansion. The other gentleman is Vinod, former founder and CEO of CloudCherry that was sold to Cisco. Vinod today is based out of Silicon Valley. Because of this, the next session, session 4, will start the time at 1 p.m. So please take note of the difference in time. The next session will be 1 p.m. September 4 versus a usual 4 p.m. time. And of course, my colleagues, the band will be moderating the session, talking and sharing their experience about cross-border expansion and many other activities. With this, thank you again for all of you for participating in this event, and please continue to sign up for the event, and look forward to hearing and seeing you next time. Thank you very much.